What is the burden of proof in a property tax appeal hearing? Imagine standing in front of a panel trying to prove that your property's assessed value is too high. Who needs to show the evidence? That's what the burden of proof is all about. In a property tax appeal hearing, the burden of proof means which side has to provide convincing evidence to support their claim. Usually, it's the property owner who is appealing the assessment. They need to show that the assessed value is incorrect and that it should be lowered. To do this, the property owner can bring in different types of evidence. This might include recent sales of similar properties nearby, professional appraisals, or detailed reports about the condition of the property. Oral testimony from experts or witnesses can also be part of the evidence. The goal is to prove that the current assessment is too high. However, there are situations where the burden shifts to the assessor. For example, if the property is an owner-occupied single-family home, or if the assessor used a different value than what was paid when the property was bought, the assessor must then prove that their assessment is correct. They need to show that their valuation is fair and based on proper methods. It's important to remember that only evidence presented during the hearing counts. Anything submitted before the hearing or discussed outside, it isn't considered unless it's officially introduced during the session. If you're relying on an appraisal or expert report, the person who made it must be available to answer questions. For property owners preparing for a hearing, gathering solid evidence is key. This includes recent comparable sales, official appraisals, and documentation about the property's condition. Even if the burden is on the assessor, it's wise to be ready to present your own evidence. All evidence must be shown during the hearing, and witnesses or experts should be prepared to testify. Understanding who has the burden of proof and what evidence is needed can help you plan your case better. It makes your chances of a successful appeal much higher.